Name, sir?
Johnson.
Okay. What are we doing on this one?
Okay, well, it's number 5 and number 7 are duplicates. They're the exact same thing, same date and time. But he was pleading guilty to the violations. It's a combination of positives for alcohol and for missed sobriety tests.
If you plead guilty, so I'll just dismiss count 7. Is that fair?
That's fine.
So he's going to plead to 1 through 6.
Right out of the gate, this case is already heading downhill. We're looking at a defendant facing multiple probation violations, missed breath tests, repeated alcohol positives, and a judge who's making sure the consequences are crystal clear. This isn't one mistake or a technical slip-up. It's a pattern forming in real time. And when a judge warns you that pleading guilty could land you in jail for up to 93 days, that's not routine courtroom chatter. That's a flashing red light. The big question is, does the defendant understand how close he is to losing everything?
Give me 1 second. Failed to submit to 7 a.m. PBT on December 12 of 25. How do you plead?
Guilty.
And that's on the sober link, and that was on December 12, right?
Yes, sir.
Did you fail to do that?
Yes, sir.
Count 2, that you submitted a breath test through a sober link on December 13th with positive results. So that would be failing to refrain from consuming alcohol. How do you plead? Did you fail to refrain from consuming alcohol on the 13th?
Yes, sir.
Count 3, that you failed to refrain from consuming alcohol, testing positive again on December 14th. How do you plead? Did you consume alcohol, say again, on that date?
It was within 72 hours.
I didn't ask you that. Did you test positive for that and consume alcohol on the 14th?
Positive, yes.
Count 4, to the charge of failed to refrain from consuming alcohol, submitting to a breath test with positive results on December 15th. How do you plead?
Guilty.
Did you test positive that date?
Yes.
Count 5, that you failed to submit to a 7 a.m. PBT on SoberLink on December 18th. How do you plead?
Guilty.
I need Emily in here on this one. Count 6, that you failed to refrain from consuming alcohol, having a positive result on December 16th. How do you plead?
Guilty.
Count 8, that you failed to submit to a PBT on December 18th. How do you plead? Count 9, and did you fail to do that? Yes.
Yes, sir.
Count 9, that you failed to submit to a 7 a.m. PBT on December 20. How do you plead?
Guilty.
Fail to do that? Count 10, that you failed to refrain from consuming alcohol, testing positive on December 20. How do you plead? Fail to do that?
Yes, sir.
Count 11, you failed to submit to 7 a.m. PBT on SoberLink on December 21. How do you plead? Fail to do that? Count 12, that you failed to refrain from consuming alcohol, testing positive for alcohol on those dates in time. That date, December 21, at 9:04, 9:18, 9:48, October 18, October 48. I'm sorry, 10:48, 11:31, and then missed on 11:48. How do you plead?
Yes, guilty.
Did you fail to do that?
Yes.
Anybody force you to plead guilty? Please are accepted. The counts 1 through 12, with the exception of 7. Count 7 is dismissed. It's a duplicate. I think I need Ms. Decino to tell you.
This is where the legal damage becomes official. By pleading guilty to nearly every count, the defendant has now waived his right to challenge the evidence, the testing process, and even potential device errors. From a courtroom perspective, this locks the judge into a sentencing phase, not a fact-finding one. The court isn't debating whether violations happened anymore. It's deciding how severe the response should be. And with this many violations stacked back-to-back, judges often see this as noncompliance, not struggle. Pay attention here, because once sentencing begins, mercy becomes discretionary, not guaranteed.
Because I don't remember having somebody have have a malfunctioning device of any kind. Maybe there was. But for someone to have 2, 1 ticket, 150 million. I can't wait to hear, because I am really upset with Mr. Johnson. He gets in sobriety court. We told him it was a marathon. He didn't even get to the end of the sidewalk up here, and he's basically quit. Go ahead. I want to hear.
Yes, Judge, and I don't have the particulars on the hearing that's coming up, but in talking to Mr. Johnson, he's been pretty direct and candid. He's struggling with alcohol.
He lied to me under oath. He lied to me under oath. I want to repeat what I said. He lied to me under oath. I gave him every opportunity every opportunity to come clean, and you lied to me under oath. You got no business being in sobriety court. We made a massive mistake on this one. What a failure on our part to see through the nonsensical garbage. And I, as the head of this sobriety court, accept full responsibility. You lied to me under oath. You don't lie in a courtroom, son.
This is the emotional breaking point of the hearing. Judges expect relapse in sobriety court. That's part of the program. What they don't tolerate is deception. Lying under oath doesn't just undermine the case. It attacks the integrity of the entire court. You can hear the shift in tone here. Disappointment turns into anger, and frustration turns into accountability. The judge isn't reacting to addiction alone. He's reacting to wasted trust. Ask yourself, if honesty had come earlier, would this outcome look very different?
It's not about me. Not about me. You don't lie to the judicial system under oath. You don't do it. I gave him every opportunity to get off the mat. No. It's a malfunction. It's a malfunction. So I got to have people from house arrest take time from their day to come on. We got to spool around with switching out devices. And then the same thing happens. And I'm telling you, if this was a malfunctioning device, not one but two, he needs to go buy a lottery ticket. He'll be a billionaire by 6 o'clock or whenever the next drawing is. Unless you think I shouldn't terminate him, I'm doing it right now. Yeah, he's pled guilty to all these. And now his lawyer started out, Mr. Haynes, gentleman, he's struggling with alcohol, which is what I knew from the beginning. But he wouldn't tell me that. He wanted to lie to me. He wanted to assure me he didn't. I told him, you're not going to testify falsely under oath. Go ahead.
Judge, you've been around this even a little longer than I have, with this a long time. With this particular problem, you don't know when people are ready. You know, when they admit it, they see the light. A lot of times people take a long time trying to get away with things, and it becomes a habit. Today, and this is not a rant for the other part of this, I met Mr. Johnson for the first time today. We talked about it, and pretty quickly we got to the point. He has been involved in counseling with the Gera. I'm hoping the court will order that his counseling is increased, possibly intensive outpatient, because he is struggling with that degree and he needs the help. I don't know exactly what's going on with him in his personal life, but he does have a job. He works at the call center, gets off at midnight. He says he's going to be doing his meetings after that. He's working toward getting a sponsor, but he doesn't have one yet. And maybe getting a sponsor would be the part of this that helps make a difference for him. But if he's made a step today that he's acknowledging this, I hope he gets a chance.
Anything else that you want to say, sir?
No. This option going through.
Anything you want to say?
Yes, I am a concerned in some capacity that I don't think it's uncommon for the early days for people to fight it. I think it is a step in the direction that he was at least honest today. I'm equally as frustrated when I think of the work I put into other violations. I'm kind of thinking that maybe a scram tether would be appropriate because now we're having an issue that is missing the 7 and 11 a.m. one. And then I would definitely want to speak to Hagera about getting him into IOP and maybe an MAT consultation. And the ETG did come back and confirm I got it today for the record.
I just don't understand. I just don't understand how when a judge lets you off the mat, and I did let you off the mat, and I told you not to lie to me, and you lied under oath. I get the whole addiction thing. We all get that. Every one of us get that. I don't understand how, when I was talking to you and I knew you were lying, and you kept assuring me you weren't lying, and you testified under oath, I would not blame myself for sending you away today for 93 days. I want to be clear about that. You just got started in this program, and you aren't even giving it a shot. And again, I get the addiction thing. We all understand that people are going to fail. They're going to relapse. I get it. But you went to such great lengths. I'm going to have a hard time forgiving you for that. I mean, you really went to great lengths. But that being said, here's what I'm doing. You're to serve 10 days jail now. I don't care who you're going to be with or not with on Christmas. That's just too bad. That's just too bad. You're going to serve Christmas Day in jail. And for you to make me do that, for me to do that, you really pushed me. You ought to know that. You're to have a MAT consultation. You're to convert to a scram tether first business day following release. So we can even take the sober length that he's on. I don't know where he got it, if he got it from house arrest. Pardon?
I'll have to take it to house. If he doesn't have it with him today, he can bring
Do you
it.
have it?
I would rather him keep it almost so that when he gets out,
It's going to be,
what if he gets out at 7 p.m. on a Saturday,
that's fine. I'll let you work on that. You're going to return that. We're going to give you a scram tether, 10 days jail, 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. This is basically about it. This is your last chance. You lie to me again, we're done. Good luck. That's what we'll do. And you can talk to Gary about IOP, intensifying the treatment.
In the end, this ruling reflects a court trying to balance punishment with one final opportunity for recovery. The judge stops short of the maximum 93 days, but still imposes real consequences. Jail time over the holidays, stricter monitoring, a scram tether, and intensified treatment requirements. The message is unmistakable. Relapse may be part of addiction, but dishonesty is not tolerated. This case highlights the fragile line sobriety courts walk between compassion and accountability, and how quickly that balance can tip when trust is broken. Backhand index pointing right if you found this case as intense as we did. Hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and real legal insight.